So in our previous videos for attorneys and home sellers, I talked to you about the risks of offering buyer agent compensation. And I mentioned that I'd be talking about some of the mitigation measures in future videos. This is one of those mitigation measures. It's also there's so much to go over. And I've been putting together for my sellers, really for the attorneys, some things that I would talk to sellers about, but create sort of a forms-driven process for sellers so they understand the need for an attorney and they understand how they can be protected. And so this is my seller instruction to listing agent. It will bring up a lot of the issues that realtors now have with respect to buyer agent compensation by the nature of the form. So if I were an attorney, I am an attorney. If I were you, who's an attorney, talking to a seller that you might be referring to a listing agent, I'd say, well, this is one of the forms I would have your listing agent, or if you were working with us, the listing broker and the co-listing broker sign. So this would be, and I'm an attorney and a broker in California, so it's definitely for California. It might work in other states too. Seller instructs the listing agent that buyer agent compensation shall begin at zero. Now, I know the first thing any realtor watching this is going to know, but we can't even put buyer agent compensation on the MLS. That's true. But nevertheless, this should be documented at zero. For lawyers to understand, like the learned hand formula, you take the likelihood of the risk, but you also might multiply it by the extent of the risk or the damage that could happen, and you decide whether you should mitigate against it. Well, here, for a simple form, we are documenting something that's very important. We're showing, and the listing agent and the listing broker and the listing brokerage and the listing company should all be very happy. They should wish they had a form like this, because this documents that regardless of what the realtor and the seller were talking about with respect to buyer agent compensation and standard compensation areas and what they might have to pay, and that it's not in the MLS anymore, but it will come in and then they can negotiate it then. Some of these things, listing agents probably will be talking about that they're not licensed to talk about, but there will be questions about buyer agent compensation. I've gone to listing appointments. I've had listings. They always want to know, well, that's your fee. What's the buyer's fee? And then I had to explain to them what the class action suits last year did to the process and why. And I imagine every listing agent's going to have to do that. But the point is that it should be documented that regardless of the conversation, we started at zero. So we weren't going into this to try to fix commissions or keep commissions high. We started at zero. Now, that doesn't mean you're going to stay at zero, but we start at zero. So seller understands that they may revisit this instruction after MLS listing. I have a more recent version. I have after the MLS listing goes active, but this is the one I pulled up that was saved. I guess when I typed it in, it was the first one that came out of the list. Any change must be confirmed in writing with counsel. Seller elects to keep buyer agent compensation at zero. Seller reserves the right to review this instruction after MLS listing. So, again, I like to make sure that the seller checks this box so they understand it, and then they give it to the listing agent. So they should ask you questions. Why am I checking this box? And again, you can make the forms any way you like. This is what I'm suggesting. Notice to listing agent. Upon MLS activation, notify seller's attorney. This is a possibility. Upon MLS activation, notify seller directly. I think that would be, a text would be good, or an email, probably text. And I'm not going to all the things like listing agents will be setting up showings and times and technology they use for that and things of that nature. I'm just saying that when it goes active, the seller should be told, because maybe at that point in time, this seller will want to talk about buyer agent compensation with the lawyer, or maybe they already have. And so this would be the third one, notify both. Again, you could eliminate that box and just have two checks. Now, post-listing instructions. So this is the idea that after it's gone active, seller or seller's attorney will provide written direction choosing one of the following postures. To remain at zero. So in this case, the intent would be, at least for now, for the first few weeks or the first few days, if a buyer agent calls up or a buyer and asks if the seller's offering buyer agent commission, the seller and the agent would say, no, it's zero. This would be for very risk-averse sellers. I wouldn't necessarily advise it Although I would talk to you, if buyer's agents come and show your property and they request buyer agent commission, and then you're going to try to counter them at zero, I mean, that might work sometimes, but I'm not sure it's better than just saying ahead of time it's zero. Because what will happen is buyers are still going to want to see your property most of the time, unless they're totally locked in. And by saying we're offering buyer agent compensation, you're giving an agent who might be working with a buyer for the first time a chance to lock the buyer into high buyer agent compensation. So there could be reasons to stay at zero for the time being, especially when the property comes on the market, because they might contact your agent, your listing agent directly to see the property, and then you could have worked out a different level of compensation with your listing agent. And technically, it might not even be buyer agent compensation. It might be compensation for working with an unrepresented buyer, if you look at the California Association of Realtors listing agreement. So that would be a strategy that a seller should consider. Now, I'll open a compensation case by case. This is probably the standard way listing realtors are doing it in California right now. And I'll tell you why, because they do want to encourage offers and showings. And most sellers, in my experience, still do want to pay some buyer agent compensation. So that would be the standard. That's a passive way to do it. It doesn't really protect the seller there's, whether you're broadcasting or being passive, there are risks. Another thing would be to state compensation privately upon inquiry. So, for instance, when my seller was interested and definitely wanted to offer buyer agent compensation, I made sure I found myself answering the phone saying, yeah, we're offering buyer agent compensation, or I'm offering buyer agent compensation. Usually I said we're, and then I'd correct myself. I go, well, it's not we're. I'm the listing agent. I don't offer buyer agent compensation. It's not my money. My seller is open to buyer agent compensation. I said it a few times. I was like, oh, I'm going to have my AI answer the phone and state it the same way every time. So I trained my AI to say it every time. That way there couldn't be a mistake, because I was concerned. What if I just said it? Because initially there were a lot of showings on a big open house, and people were constantly calling, and I responded rather quickly while two people might be standing around, and I didn't want to get my seller or myself in trouble. So I had the AI be able to state that, and then they could put the call through to me. So that would be one way to protect a seller who was concerned. Now, finally, there's broadcasting buyer agent compensation. This is allowed. I've got quotes from the NAR lawyer. I've got a video from the NAR lawyer. It is allowed, but as a circular back in March said, it's allowed. Sellers are allowed to offer buyer agent compensation, but they should do so in concert with a real estate professional. And that's the whole point. And it's an attorney who can talk about the risks, who can talk about the benefits of broadcasting. I mean, for instance, if you agree to broadcast, and I think there's very good reasons to do it, if you are letting agents know who do a lot of business in your area, if you're going to broker caravans and saying, we're offering buyer agent compensation, or we're offering an extra 0.5% for contracts we get in the next 2 weeks, or if you showed up in the caravan today signing on the book, we'll get you an extra 0.5% or percent, whatever your market's like. And there are reasons, we're not going to go into it here, but from my experience in the past, buyer agent compensation does, especially offering a little more than normal, it will get you more showings, it will get you stronger offers, and those offers will stick around, especially when they're working with a strong buyer. And it's also a way to appeal to buyer's agents who are working with reload buyers who are frequently not that price sensitive. They have to buy a house that weekend. So it's a tremendous strategy. It can be deployed at the right time. You can broadcast it. I was getting like 17-cent clicks in an open house. So if you're doing an open house and you're saying we're amenable to buyer agent compensation, and you're also marketing to sellers, you'll let Facebook market to sellers and buyer's agents, I mean, that's a good strategy. And it will get you showings. And for many houses, just our experience in California, you get 5 or 10 showings with real buyers, you're going to get an offer. So you want showings. You'd like to bunch them in all together so everyone sees the interest in the property. That makes the buyers really interested, but that's for another topic, proper marketing. Now, if a seller is interested in delivering buyer agent compensation or is open to it, this is an older one. This was an older one. I would remove this now. Please be advised that the Department of Justice has stated that offering buyer agent compensation creates risks of commission fixing, improper, unethical steering, and compromising the fiduciary duty of buyer's agents. I don't think that matters whether it's broadcast. It's just offering. Oh, yeah. Okay, I said it. So if they're interested in leveraging buyer agent compensation by broadcasting it or is open to receiving a request for it. Oh, this is my point, that it doesn't really matter whether you're broadcasting it, which real estate agents don't think you can do anymore, or you're just you're letting the passively offers come to you. You're still creating risks that have to be mitigated against, in my opinion, especially because some of the risks can be easily, if you're agreeing to pay the full amount of buyer agent compensation, you can strongly mitigate your risks. I mean, I don't think the buyer's agent's going to balk when they're getting paid 2.5% or 3% just because you're making them sign an extra form or two and you're educating their buyer and say, we're offering this as a convenience, but you need to understand this and sign off on it. I mean, it's not difficult. So, I've got this form. This is really about the training. You've seen the form. You could probably make your own now. But this form and a lot of other training in my free video series at listingattorney.com. But I'll put this form in. Now, actually, I already did before we started the video. I moved it from my attorney membership area to the free membership area. So you'll be able to see it. Now, once you're there, there's free training. And we're about to explain to attorneys how they can get paid. And I will tell you that you're doing high-value work as an attorney, counseling your seller, mitigating against the risks, discussing the counter language, possibly working on disclosures. There's so many things an attorney should now be doing that I think you're doing more than you're earning more than half the commissions of the realtor. And, RESPA and the Bar Association would have something to say about 50% referrals. I mean, they're probably illegal. But for doing the high-value work, I don't think they are. So then the question for attorneys then is, what is the mechanism for you to get paid a share of the listing agent commissions legally? And that's what the remainder. I've already covered a lot of the important points of the course. So pretty soon, if it's not the next video, it'll be 2 videos from now, we'll talk about the right structures for attorneys who want to get paid $6,000 to $10,000 or more for doing the work, protecting their clients, and helping them sell for more and get a higher net. My name is John McConnin. I'm a broker and attorney in California. Learn more at listingattorney.com. Thank you.